Judgment is expected in the perjury case of former Social Development Minister Bathabile Dlamini in the Johannesburg Magistrates Court this morning. This in connection with her testimony in the South African Social Security Agency debacle in 2017. Dlamini has denied intentionally lying in the matter, and we'll take you there live right now.
July 2016 between Sassa and the head of each work streams as indicated. The question here was by Judge Mwepe in the affirmative, answered in the affirmative. See paragraph 9 of the report at page 13, line 21 to 23. Paragraph 54 herein. Question 2B, question 2 sub B, Roman figure 2, which was whether they reported directly to the minister. Finding by the judge responded to this question as follows. The second part of the question 2A, which I've answered in the affirmative, was whether the minister had sought the work streams to report to her directly. Now, the present question, as I understand it, wants to establish whether the work stream did actually report directly to the minister as directed by her in a letter the 9th July 2015. Given the context of the case, reporting directly to the minister means reporting to her, even if it be through Ms. Mvulane, in bracket, as opposed to reporting to Sassa or its CEO. This would be in line with the letter and the spirit of the minister's directives as per the letter dated 9 July 2015, referred to above. Report to me directly as opposed to reporting to Sassa or its CEO, close bracket. B, he further stated that I am also of the view that even on probabilities, the work streams reported directly to the minister through Ms. Mvulane. A, the letter of 9 July 2015, it is highly unlikely that such an express instruction by the minister would be disobeyed, particularly because no action was taken by the minister against Ms. Mvulane for keeping her in the dark. Given the importance of the matter and the publicity it attracted, the minister wouldn't have simply allowed herself to remain uninformed. She must have known what was happening. Paragraph 12 therein. For all above reasons, my answer to the question is in the affirmative. Here is my emphasis also. See paragraph 10 to 11, page 14, line 8 to 13, and page 18, line 2 to 13. Paragraph 55. The question 2B, Roman figure 3, pertaining to full details of the dates and the contents of their reports to the first respondent in relation to the objectives stated in the third respondent's, in bracket Sassa, report filed with the court on the 5th November 2015, no information was provided, despite a list of documents being alleged to have been submitted, but they weren't to the judge. Close bracket. Thus, it is this court's view that the reasonable inference to be drawn in that is that the alleged documents may not necessarily prove what they alleged. Paragraph 56. Question 2B, Roman figure 4. The reason why the minister did not disclose to this court, that is the Constitutional Court, that these individuals were appointed at the instance and that they had to report directly to her. A, the judge said this aspect has already been dealt with above. The work stream did report directly to the minister and not to Sassa, which was why Mr. Magwaza, the CEO, complained, as did Mr. Dengo. See paragraph 19. See page 19, paragraph 14.1, line 14 to 16. B, Furthermore, the judge stated that, I therefore proceed to deal with what appears to be a reason why Minister did not disclose information in question. There were two things only which the Minister was called upon by the court to fend off: being joined in her personal capacity, and that happening being malacted in court in a personal capacity. The reason for not giving the information in question can therefore only be related to these two things. In contrast to all other conceivable reasons, conjecture, etc., fear of the two is therefore not something sucked from the thumb. We now know that the Minister had already been joined in a personal capacity, but at the time she made the affidavit which did not disclose information sought. This was, of course, not yet the case. Fear of being joined must therefore be factored in. C. The two issues were the only ones the Minister was answering to. On the face of it, the information was not disclosure. On the face of it, the information not disclosed was inimical to the Minister's case in fending them off. The fear of them as the reason for non-disclosure therefore commends itself more readily to mind than any other reasons. That then, to me, is the reason why the Minister did not disclose. That these individuals were appointed at her instance and that they had to report directly to her. Page 21, paragraph 14.4 to paragraph 14.5. Page 57, paragraph 57. In respect to the Minister, in respect to the first question, the judge viewed it as follows. I quote, "In my view, however, this issue is more related to the question of apportionment of blame for the crisis than to the actual question posed by the court. Did the work stream report directly to the Minister?" It's a question. I am able to deal and report on that question without resolving the debate about the existence or non-existence of parallel structures. Close quote. 58, paragraph. In his inquiry, Judge President Mwepe, in paragraph 4, in line 13 to 15, page 5 thereof, he stated that he was not asked to make a finding whether the Minister, the accused, herein had acted in bad faith in the grand saga. In the present case, it was argued, amongst others by the defense, that no adverse finding was made against the accused therein. Instead, all the questions were answered in his findings. Therefore, following Judge Mwepe's finding in relation to the issue indicated here in paragraph above. A. Or should I say the conclusion, actually. The accuser's counsel in Section 38 inquiry, despite having conceded that there is a scarcity of reported cases on proceedings in relation to the said inquiry, it was held that by Judge Mwepe had argued and is similarly argued on behalf of the accused in these proceedings with reference to the case of A.P. Wright versus W.R. Wright and another 2015-1 SA 262 in bracket SCA, that the referee in that inquiry cannot make credibility findings or make conclusions of factual findings. To quote the judge verbatim, he stated, I quote, "This approach is wrong. For one thing, the labeling of a particular function may in itself be wrong. In my view, the point of reference as to what a referee may or may not do are the terms of the mandate. The scope of each inquiry is therefore determined by its own terms of reference. If a proper and full execution thereof requires of the referee to hear oral evidence, the referee will do so. If credibility findings have to be made, the referee will do so. So too, when it comes to factual findings or conclusions, if they were to be made. In the present instance, the mandate to the inquiry is not only to inquire into, about, but also to report on the questions posed by the court. I am of the view that in order for me to execute my mandate properly, I must do all the above. It is also not lost on me that the court chose a judge, hopefully experienced enough to deal with all those things, but of course only with reference to and with the ambit of questions posed. Witnesses were examined and cross-examined, with senior counsel representing them. Finally, I'm emboldened by the comfortable knowledge that it is unlikely but possible event I am wrong, the court would correct me. I would rather do more than what is required of me than fall short of fully executing my mandate, because that could leave the court in an invidious position. Refer the matter to me again. Surely that scenario I must avoid. Close quote. Paragraph 59. At page 5, the judge also referred to Section 6, Subsection 2 of South African Social Security Agency, Act 9 of 2000, which provides that the Sassa CEO is accountable to the minister and must report to the minister on the activities of Sassa. Paragraph 60, I shall also refer to that, or touch on that above later in my judgment, to respond to the contested issues as was argued by the parties. The oral evidence, which is now paragraph 61, is as follows. Mr. Magwaza took over the office of Sassa as CEO with effect from 3 November 2016, despite that his appointment was from July 2016 as per minister's request. Prior that, he was acting Director General of the Department of Social Development. He learned then of Ms. Zodwa Elaine Mvulane, that Ms. Mvulane's appointment as the Workstream project leader. Ms. Mvulane was to liaise with the Workstream leaders. Paragraph 63. On the 24th of October 2016, whilst an incoming CEO, he was invited to attend the Workstream's official presentations. Whilst there, Mr. Metcalf, one of the Workstream leaders, was presenting. He raised a concern that their structure on slide number 14 indicated that the Workstreams are to report directly to the minister. They accuse here, instead of Sassa ESCO or Executive Committee, as was expected. According to him, this was an indication that Workstreams were reporting to the minister, bearing in mind their appointment a couple of months earlier. Workstreams requested a couple of months from the minister to do their due diligence. Paragraph 64. He had no issues with the Workstreams and was impressed with their overall presentation except for their governance structure. However, it had appeared to him that even after he occupied his office as a Sassa CEO, the Workstream was still not reporting to Sassa's EXCO. Ms. Mvulane, as Sassa's EXCO member and Workstream project leader, was supposed to report back to EXCO on what was taking place with the Workstreams. However, she only shared certain information but not everything. In fact, they learned about certain information long after the effective meetings took place. Consequently, ESCO members complained as she was not reporting to the, members complained as she was reporting to the minister, the accused. He had raised this issue previously with Ms. Mvulane on one-on-one due to these complaints by EXCO members. He was adamant that the Workstream had never reported to ESCO as Sassa's formal structure. He He conceded, though, that they may have reported to Sassa's technical staff. Apparently, in one of the meetings held in Limpopo, where the work stream reported and presented, they indicated that they've been working underground since June 2015. Thus, in March 2017, he wrote to the minister about the issues he had with governments, also Ms. Mvulane and the work streams, but he didn't receive any response from the minister. Paragraph 66. According to him, Ms. Mvulane had presented in respect of the work streams at Emperor's Palace and in front of post office staff, where the minister was present, and other than the meeting in Polokwane. He also attended another conference in Cape Town around February or March 2017, where the work stream presented in preparation to the end of ministerial task team. The minister's office invited him, though he attended alone without his EXCO members. Present there was him, the minister, Dr. Mapasela, as well as Sassa, his former acting CEO, Ms. Rampathle. He alluded again to the fact that accused, as the minister, had received regular briefings from Ms. Mvulane as the work stream project leader in respect of what the work streams were doing at the time. Thus, according to him, in essence, the minister had attended 2 other meetings where work streams reported directly to her. He further alluded that the work streams were appointed at the minister or accused's instance. Paragraph 67, he confirmed that he and the accused testified at Section 38 inquiry. Prior that, he filed an affidavit dated 7 April 2017 to the Constitutional Court. He had attached to his affidavit accuser's letter dated 9 July 2015 as Annexure A thereto. This was to support his version that accused was behind the work stream's establishment. He highlighted paragraph 5 of accuser's letters, which according to him was suggestive of this, where she stated that, to this end, I have decided to retain the services of the following individuals who were part of the committee of the implementation of their recommendations. The names already been placed on record earlier on. And he therefore said, although this panel will account directly to me, during the implementation process, I request that Sassa appoints hosts to provide resources and compensate panel on behalf of the department, subject to applicable law. My emphasis also here. Paragraph 68, he highlighted with reference to both accuser's letter, Exhibit B1 as indicated above, paragraph 25, and accuser's unsigned statement dated 30 November 2017, paragraph 30 thereof, that the interchangeable use of the words accounting and reporting by the accused as a minister then and when she testified at the Section 38 inquiry, where she further stated, it is true that I directed that the specified work stream leaders be appointed by Sassa to lead work streams, and that the leaders of the work streams will report directly to me during the implementation process. My emphasis. According to him, all these illustrates, therefore, that these words mean one and the same thing, at least according to him. Paragraph 69, he further stated that a couple of months prior to his resignation at Sassa, he received a letter from the National Treasurer on the work stream's legality. Thus, towards the end of June 2017, he called a meeting to meet with Ms. Mvulane and the work streams and after some deliberations with the EXCO members and consultation with the minister undertook to help resolve the issues from the National Treasurer. After speaking to the then Minister, Lucy Gigaba, and Standing Committee on Public Accounts, that is SCOPA, the Minister, however, did not revert to him, and since they had only 3 days, he had no option but to terminate the work stream's mandate. Paragraph 70. At the time, the situation at Sassa had become unattainable and his life was under threat. He opted to leave Sassa. He had a mutual agreement with the minister and left Sassa. Only 9 months of occupying the office of a CEO, or as a CEO, he explained that prior and after leaving Sassa, his relationship with the minister, the accused, had always been cordial. He had never seen accused as his enemy, nor does he think the minister or accused sees him as an enemy. His evidence concluded the state's case, along with all the exhibits I've mentioned above. Paragraph 71, the defense applied in terms of Section 174 of the Criminal Procedure Act for the accuser's discharge. The state vehemently opposed the application. Both parties addressed the court. The court had, after considering all the presented evidence, found the state had a prima facie case that had left some questions which only the accused could answer. It was further this court's view that another court may, after serious consideration of the evidence, find similarly. Therefore, the accuser's application for a discharge was accordingly refused. Paragraph 72. The accused thereafter, as indicated above in paragraph 7, elected not to testify. She claimed that her evidence would have been, in essence, the same as testified to at the Section 38 inquiry, and that she had nothing further to add to that. See Exhibit B3. That is the transcribed record of proceedings, which contains, amongst others, accuser's evidence at Section 38, as alluded to above. The accused instead opted to call Ms. Zodwa Elaine Vulane, one of Sassa's ESCO, member of the Work Streams project leader, to testify as a defense witness. Paragraph 73. Ms. Vulane stated that she was appointed Work Stream project leader for period of their establishment when they were appointed in July 2016 until termination in June 2017. She regarded herself as best suited to lead Work Stream instead of Mr. Magwaza, who was not at Sassa when the Work Streams were appointed. She was seconded to the role by the minister because she was familiar with the whole Sassa process. Her functions as the project leader were to get the Work Stream to deliver on their mandate to ensure that Sassa met its deadline as was ordered by the Constitutional Court, as one can recall from the background above. Sassa had to position itself by 31st March 2017 to pay the social grants beneficiaries in-house with effect from the 1st April 2017. Paragraph 34. It was a very crucial period at Sassa since the cash pay master service contract with the Sassa was declared invalid by the Constitutional Court. Therefore, Sassa, its leaders, and EXCO, Department of Social Development, its minister, that is the accuser, all were under tremendous pressure to ensure Sassa was ready come 1st April 2017. The Work Stream, though appointed in July 2016, only provided their first report on 24th October 2016 after conducting due diligence. She was in constant discussion with the Work Stream pertaining to their work and progress. She had countless meetings with them as they reported directly to her. She also met other stakeholders, mostly on a weekly basis. It was further her evidence that the Work Streams met the minister twice, where they reported directly to the minister. In relation to Exhibit B1, accuser's letter dated 9 July 2015, she stated that the situation at the time created a parallel reporting after CPS's contract being declared invalid. They were, on the other hand, reporting to the Constitutional Court whether they were going to be able to do the payments of social grants in-house. Hence the appointment of the Work Streams. They needed to achieve 7 deliverables before they could be in a position to do the in-house payments. On the other hand, they had to report to the governance committee. She explained that there was so much pressure to deliver, especially taking into account that there were about 12 million social grants recipients expected to be paid. Thus, according to her, it would not have been unreasonable for the minister to expect an update from time to time. Since Sassa failed to pay grants, she was ultimately to be held accountable to the whole country. Paragraph 76. As the workstream project leader, she reported to Sassa's EXCO, its leadership, CEO, and to the then minister, that is the accused. The EXCO will then update and brief the minister at least twice during Ms. Ramukhupa or Rampatle's stint as Sassa's acting CEO. Mr. Magwaza took over as CEO on the 3rd November 2016, and on the 24th October 2016, he was invited to the workstream's presentation as Sassa incoming CEO, even though the accused was absent there. However, as early as August 2016, she had briefed the minister, the accused herein, where she introduced the 3 appointed workstream leaders to her. She met her again on the 5th October 2016 when the workstreams requested to present to the minister prior presentation of the 24th October 2016. The other time it was at minister's behest when they met legal workstreams who were to help them prepare affidavits to be presented at the Constitutional Court. The said meeting revealed that it was not possible to achieve the deadline as was
Make your
intended
computer easier to use.
by Sassa.
Windows will read and scan this list automatically. Press the space bar to select the highlighted option. Rest. Sticky keys. High contrast. Windows sign in. Pane. View. Make your computer.
All right, we just lost the link there to the Johannesburg Magistrates Court, wherein the judgment was being handed down of former Social Development Minister Bathabile Dlamini, who faces perjury charges.